Hi, I'm Debbie Moraes, and this is Legal Matters, the program that's designed to address the critical issues that are facing businesses and consumers today. It's legal information, it's practical solutions, and straight talk about a wide variety of topics as we've been doing. Most recently, they've covered things that are addressing the poor economy. Not surprisingly, pre-foreclosures, foreclosures, auctions, short sales. And today we're going to be discussing something also that's the direct result of the economy, namely people being taken to small claims court. Our last topic with Jackie, while she was here and David was not, we were discussing short sales. And we always ask that our viewers send us some sort of email question as a follow-up to the questions or the information that we presented to you in the previous session. So Jackie, David, if you would like to address it too. The question this week that we received was about the short sale. We discussed briefly that there are taxes that are involved with short sale. What happens if it is not your primary residence but rather a vacation home? What's the story?
If it's not your primary residence, you're not subject to that Mortgage Relief Act that's in place until 2012. So therefore, any debt cancellation or delinquency from a foreclosure or a short sale, you will be taxed on that. You will be taxed as income. And to remind everybody, anytime a debt is forgiven, that is considered gross income by the IRS. So there's no free rides.
And that doesn't matter what state? Rhode Island, Massachusetts?
No, it's a federal law.
Florida. Okay.
And it's a 1099 that you'll receive from the creditor who forgave a portion of the debt.
Yep, 1099-C.
Good enough. Thank you. So, as we're talking about, or beginning to think about small claims court, you have, I think most people think about it in terms of not being able to collect on a receivable, but I understand that that's not all there is. So give us a little tutorial or backgrounder on what happens at small claims court.
I'll start with Rhode Island. Okay. In Rhode Island, the only kinds of cases you can bring to a small claims court are contracts, which would be receivables. If you contracted to buy something and didn't pay for it, the seller could take you to Rhode Island Small Claims Court, which is the district court. It's a division of the district court. And the jurisdiction there is for any claim up to $2,500. Massachusetts?
Massachusetts is $2,000. And just to talk about jurisdiction, same type of jurisdiction in Massachusetts. When David says contract, what he's alluding to is money that's owed for services. It could be someone who painted your house and you have a dispute about that. But generally it's money owed for services. Medical bills are frequently in small claims court. Any credit card bill that you may have that was unpaid for a period of time, as long as it's under $2,500, it can be presented in small claims court.
Is it possible? I think I read something about Connecticut being $5,000 as the limit. Is that a possibility?
Every state has its own court of that type, which is for collecting contract cases, bills, those types of things. Well, they'll have their own jurisdictional limits. So it will vary state to state. So if Connecticut has 5,000, that's very possible.
They tend to raise the limits. Rhode Island, I think a few years ago, was $1,500. They raised it to $2,500. And the other thing you should know is small claims cannot give you like a restraining order. You can't get injunctive relief from small claims court. In other words, I don't want a person to trespass on my property. Small claims doesn't have authority to do that. That's not their jurisdiction. You have to go to a higher court to have that relief. It's called equitable relief. You go to Superior Court.
We may have talked about that at one time or another on one of the other shows, the difference between seeking damages in court or seeking a remedy such as an injunction. Goes back to the English common law where there were two different courts, the Court of Chancery, where you could go in and get equitable relief, as Jackie's saying. And courts can have jurisdiction granted upon them by the legislature to give some equitable relief. For district court, for example, has some equitable powers for trespass and ejectment cases where you can throw somebody out of a house.
Landlord-tenant. Yeah.
Landlord-tenant. Restraining orders. Typically, if you're married or it's a relative, you'd go to family court. That's an injunctive type of relief. It's restraining somebody from doing something. In district court, primarily in small claims court, when you sue somebody, all you can get are money damages.
Interesting. Now, considering we're here speaking with Jackie Grasso and David Bazar from Audette Bazar, Cordeiro Grasso law firm, I understand that when you're in small claims court, you really don't need a lawyer. True, false? What's the shortcomings if you don't have one?
Well, let me talk about the consumer side, and you
Right.
can speak about the corporate side. Given the amount of damages that one may be seeking, it could be anywhere from 0 up to 2,500. Of course, you're not going to file for 0, but to go through the expense of hiring an attorney, it may not be feasible for the individual. Is it always a good idea to have an attorney with you? Yeah, that's always a good idea. But it's, I think small claims is a way of avoiding having to litigate matters for lengthy periods of time.
It's designed for people to be able to go in, get the form from the clerk. It's a pretty standardized form. Check this box off for what type of claim it is, fill in what your claim is about. You mail it out by certified mail. I think the court may even send it. And then there's a response sheet that the defendant gets and the defendant can fill out. So it is designed for people to represent themselves. What Jackie was referring to a little bit on the corporate side was certain corporations, most corporations, that are in small claims have to have an attorney. You can't represent somebody unless you are an attorney. And a corporation, by law, is its own individual identity. It's its own entity. So you can't go as the owner of the business in most cases and say, I'm here representing the business because you're not an attorney. However, and a lot of judges, I don't think, really enforce this. If you're a closely held corporation, a small business with assets under $1 million, there is a rule in the small claims procedures that says you can designate someone to represent the corporation, meaning I own the business, it's a sole proprietorship, for example, but it is incorporated, but it's just me. You can designate on a form that we have less than $1 million in assets, that I'm the person who's going to represent the company and I'm authorized to represent the company.
It does mean, though, that whoever is the plaintiff, the suer, that they have to put together all of the documents that are required, and I understand that then the defendant, the person who is being sued, needs to be able to respond. Is that something that typically a layperson can do?
Oh yeah, for instance, I used the paint example earlier. Of course, the defendant's going to have his bill for services. Let's say the plaintiff's position is the paint is peeling 3 weeks after the paint was, after the house was painted, or maybe it was just a room. And with that, you want to bring, typically you should bring somebody who is in the same business. So you want to hire another painter and get an estimate. You don't want to bring the estimate to court, you want to bring the other painter and the estimate, because at least now you have somewhat of expert testimony. But the judges will allow an estimate, but it can't be from Uncle Fred. It has to be
a bona fide,
a bona fide individual or contractor.
And typically what happens, to use the other side of that same equation, let's say it's the painter. He did the job. He has the contract that was signed. The person never paid, or they paid a deposit, never the balance. So he's suing for a $2,000 balance on a $5,000 job, say. All he would need to do is have his evidence, as Jackie says, lined up. In that case, he needs his contract. He needs to be able to testify it was signed by the person whom he's suing, that he did the work, and that they didn't pay. So small claims cases typically, as long as you have your evidence lined up, you go in and represent yourself. And the judges are used to people coming in to represent themselves. There's also another thing that they do in small claims in Rhode Island these days, mediation. They have volunteer mediators, so the judges will send cases out to the mediators, see if it can be resolved before it has to be tried. We had a whole show on